The purpose of this video is to demonstrate how a federal prosecutor might proceed in front of a grand jury to obtain a criminal indictment in the case of Wisconsin Supreme Court Chief Justice Shirley S. Abrahamson. Here now is the citizen indictment of Shirley Abrahamson. Members of the special grand jury, I will present to you clear and irrefutable evidence that Wisconsin Supreme Court Chief Justice Shirley S. Abrahamson has fostered a culture of corruption in the Badger State. With full knowledge and for her own benefit, she has directly and indirectly enabled judicial corruption while presenting herself to the public as an ethics reformer. I will first list the charges against Ms. Abrahamson and then detail each count with full documentation. Count 1. Shirley S. Abrahamson has accepted campaign donations from attorneys with active cases before the Wisconsin Supreme Court.
I am not going to solicit campaign contributions. I am not going to solicit campaign contributions.
You've raised about $1 million so far for this race.
I have.
Your opponent, Judge Koshnick, says $30,000 of that came from trial attorneys who have cases pending before the Supreme Court, and that's just not right. What's your reaction to that? Have you given any thought to saying, I'm going to give that money back just because I don't want to have any appearance of potential conflict?
The amount stated is less than 3% of the total contributions. That means in my campaign...
And you're comfortable with keeping that money and accepting it?
Let me say that the issue is whether I should sit on a case, on any case, and you decide whether to sit on a case on all the circumstances of the case. All the circumstances. And I can't let anyone push me out of a case by making a contribution or trying to make a contribution or influence me by any contributions.
In other words, Shirley claims to have somehow tricked the lawyers trying to bribe her by taking the bribes and then refusing to recuse herself. This is totally illogical. Why would they want their bought and paid for judge off the cases? Count 2. Shirley S. Abrahamson has violated her oath to uphold the United States Constitution and Wisconsin Constitution by publicly advocating the citation of foreign law in Supreme Court decisions. Count 3. Shirley S. Abrahamson has defrauded the people of Wisconsin through a series of public hearings that were supposed to have resulted in an overhaul of attorney oversight and discipline. The actual result was the simple rebranding of the Board of Attorneys' Professional Responsibility with a new name, the Office of Lawyer Regulation. There was no substantive management or procedural change. The only real change was a sanitizing process. Under the new name, existing citizen grievances against Wisconsin's worst attorneys were scrubbed out of the system. Count 4. Shirley S. Abrahamson had specific knowledge of the impanelment of an unconstitutional secret jury in the state prosecution of a political prisoner. She did nothing. Count 5. Shirley S. Abrahamson had specific knowledge of egregious judicial criminal conspiracy and misconduct on the parts of several judges in the Madison area. Since 1858, Wisconsin has had a law on the books known as the John Doe Law. The John Doe Law allows a person who believes a crime has been committed to complain directly to a judge. The judge must then conduct an investigation, sometimes behind closed doors, to determine if a crime has indeed been committed. The law was designed to give people another avenue to make sure that the state's laws are enforced in the event a district attorney decides not to pursue a case. As an officer of the court, Ms. Abrahamson was obligated to report this misconduct to responsible law enforcement agencies. She did nothing. Count 6. Shirley S. Abrahamson has been a knowing conspirator with the Trial Lawyers Association in finding unlimited liability opportunities in frivolous lawsuits against the private sector. These lawsuits have crippled business and the economy of the state and have contributed to the deindustrialization of Wisconsin for the benefit of predatory personal injury and class action attorneys. So-called victims receive very little benefit compared to the massive windfalls for the state and attorneys. Count 7. Shirley S. Abrahamson has conspired to create a captive venue in the Dane County Circuit Court to increase her reach and power. Cases involving prisoner due process rights, insurance, and any case involving suits brought against any level of Wisconsin government are heard exclusively in the Dane County Circuit Court. Many of these cases against government involve property rights. The Dane County Circuit is the infamous venue of the Mike Dorough and Stephen Megritz cases. This has permitted large corporations like First American Title, involved in big development projects, to focus their legal and money resources in a single circuit court, and county government to circumvent the rules of title and deed filing and to subvert due process. The proximity of the Dane County Circuit to the Appeals Court, Supreme Court, and Federal District Court creates a vertically integrated star chamber where efforts to appeal a bad circuit court decision are dead on arrival. Count 8. Shirley S. Abrahamson specifically allowed attorney Paul Kasprowitz to prey upon innocent clients in the state of Wisconsin. There was ample evidence over a decade ago of Mr. Kasprowitz's dangerous incompetence and irresponsibility, yet the desperate pleas of his victims were ignored by Ms. Abrahamson. Count 9. Shirley S. Abrahamson specifically denied the habeas corpus rights of Wisconsin resident Stephen Megritz. She had specific knowledge of his plight and was obligated under Wisconsin's John Doe laws to investigate. She was complicit in a conspiracy to deny Stephen Megritz due process. Count 10. Shirley S. Abrahamson had specific and detailed knowledge of criminal acts committed by officers of the court and public officials in the landmark Dorough case. Ms. Abrahamson was complicit in the elevation of forgery to an acceptable procedure in property transactions. For this alone, Ms. Abrahamson is proven totally unsuitable to function in the highest judicial position in the state of Wisconsin.